Okay, so today what we are talking about, this is what was advertised as what the topics are. I created this list because I knew as a practitioner that these are the questions I would have wanted the answers to. As I was preparing this lecture, I sort of realized that I had a different flow in the way I wanted to answer these questions. So all these questions will be answered, but not necessarily in the order that were advertised. However, they will be answered in detail. So who am I? Why do I get to teach this lecture? So a little bit about me and why I would be the person you're hearing from. So I graduated law school in 2006, and my primary area of practice has been criminal defense work. I was a public defender for 6 years for the first 6 years out of law school in the Baltimore City division of the Maryland Office of the Public Defender. For the last 7+ years, I've been a private attorney at Zirkin and Schmerling Law, and handling primarily criminal defense, what I call criminal defense adjacent cases. So that firm, they do personal injury and family law work, and I handle criminal defense as well as Office of Administrative Hearing matters for MVA cases and protective and peace order matters. And so while I was practicing, I was always the type of lawyer that like all of us, we wanted the best for our clients, and I wanted to see the case through to the end. But when I was practicing, I noticed a lot of lawyers, when they got that not guilty or the charges were null prossed for their clients, they were very happy, shook their client's hand, client walked out happy, and that was the end of the interaction for really a vast majority, if not close to almost all of it, attorney-client interactions. Even as a public defender, I would take my clients to the clerk's office if I thought they got an expungible result and fill out the forms with them. And I wish all lawyers would do this. To me, that is really seeing the case through to the end if they are eligible for expungement right away. And so that was who I was. But then in the last 2 years, we're all charitable people, and I just decided that I wanted to use my legal skills to give back to the community. I thought that was the most effective way I could do that. And so I started reaching out to nonprofits such as drug treatment programs and homeless shelters, and establishing my own private partnerships with them, and saying I'd love to just help out pro bono and help out people. And they let me come in and help out their clients with looking into expungements. And in the last 2 years, I've represented over 800 people pro bono to expunge over 7,000 cases from their criminal records. And realistically, that's what makes me qualified to do what I'm doing here today, because through that sheer volume of people that I've assisted, I've been able to see truly how this process works statewide, county by county, the little ins and outs, and I'm pointing them out. The other thing that I bring to the table by being the teacher is that I am in private practice. I'm a criminal defense attorney, and I'm a business person. And the reason why that's relevant to you all is that, we want to be helpful. We want to help people out. But at the end of the day, it's important to know how to help people out efficiently so we can help out as many people as possible. So a lot of my lecture today will go into being mindful about that, but in a way that always makes the client feel happy and you are doing the best for them. So, I'm sure you thought, what is an expungement should be the first slide, but that's not how I want to start this off. I think the best way to start off a lecture like this is truly from the place of the client and what they asked you. And this lecture is designed for both the most experienced criminal defense attorneys as well as the attorney that is either their first day out of law school or very experienced but never done any criminal cases but gets asked a quick question like this. And you are all going to get answers to your questions today. And so what happens is, we've all been there. A client or a person on the street comes up to you and says, you're a lawyer. Can you help me to get my record expunged? And when they ask that, it seems like such a straightforward question. But as I will be pointing out, this is a very positive word, and clients latch onto these positive words and just think they're asking you a very simple question. And you need to be ready to answer that in many different directions. And so that's what this lecture will be getting into. So what might they really be asking about? Well, for the easy one is they're always going to say, I want everything to be expunged. But what I want to point out is 2 different people that are asking that question, you're going to give them very different answers. And the reason for that is, they want everything to be expunged, but all you're able to do is help them to get everything that is eligible. And so for one client, the answer is, yep, I can get everything off your record. And for other clients, it's, I'm going to help you to get as much as possible, but at the end of the day, I can only get what the statute allows, and that's what's eligible. And some things might not be able to come off your record. It's very important to be honest with clients up front about this. When I meet with people, they consistently come up to me and say, I heard you can get everything off my record. And I, one by one, make sure every person knows I will get everything that is eligible off your record. That kind of honesty and candor with the client will make for a much better relationship down the road. Sometimes the person's asking you about something that's not eligible for expungement, or maybe they're asking if you can help them out to pardon something from their record. Now, pardoning is not part of this lecture at all. It's actually a very lengthy process. I know that from the governor's website, there's an application that's very lengthy that you can go and find. This is something that an act of clemency by the governor's office, but is not part of the expungement process. Now, if something is pardoned, you can get it expunged. But if somebody says, I have something on my record and I cannot get it off my record, you're not able to do that with a simple expungement if it is a conviction that is not provided for by the statute. So just be mindful of that. Sometimes your client is going to come up to you and say, I was in court and either the judge that day or my lawyer that day told me that if I did really well, that this case was absolutely going to come off of my record. And then you look into it and you're versed in the statutes and you realize, yeah, I see what you're saying, but you got a result that is not eligible for expungement for one reason or another. Why did you think that? And a lot of times, what that client is doing is they latched onto the positive thing they heard in that courtroom. The judge or their lawyer said that they possibly could get this off their record, but they didn't really take in the legalese. And what was going on there was somebody was probably saying to them, file a motion to modify, we'll preserve your right on this conviction to come back and seek modification at a later date to get your conviction struck, and you'll get a probation before judgment. And we'll talk more a little bit later about PVJs being eligible for expungement and how that works. But if the client is at this stage, you're not talking to them about an expungement. You're talking to them about whether a new motion to modify needs to be filed. There are specific criteria for that. I provided the rule here in Maryland that sets out the rules for exactly how motions to modify convictions work. It's Maryland Rule 345. There's a 90-day time limit to file it after the client was sentenced in the first place. You're going to have to file a motion that preserves your right to come back at a later date after that 90 day. It's a motion to modify to be held sub curia. But this is what you are going to have to be able to explain to your client if something just doesn't make sense and they said, no, I was told it could come off my record. If the client missed that 90-day time limit, it's important to know it's possible, I'm not even guaranteeing this, but it's possible their only remedy may be something called a post-conviction. This is not a post-conviction lecture. However, there are certain rules for that, and deciding whether or not it's possible to reopen the case and file a belated motion to modify the conviction to a probation before judgment so that you can ultimately do an expungement. As we talked about in the advertisement for this, I said we were going to talk about what is shielding. And so there's two kinds of shielding. And there's shielding. The first one we're talking about is shielding of convictions. Now, shielding basically, it's a lot more restrictive than you would hope it would be. I've printed on this slide straight out of the statute the only 12 crimes that are even eligible for shielding. They're listed there. You don't have to write them down. I've written down the statute that's in your handouts of where you can find all of them. When we get more into this, you're going to start noticing that most of the crimes listed here are actually listed in the eligible convictions for expungement. And so how is it that you're going to learn later that we have so many more crimes that are eligible for expungement than we do that are eligible for shielding? Well, the answer to that is, think about the order these laws came in. We had originally a law that provided for a very small amount of convictions that could be expunged. Then a few years later, they came out with a shielding law that said, all right, well, you can shield a few extra convictions. And much more recently, we have a law that says you can expunge a lot more convictions. So at this time, these are the only 12 crimes that are eligible for shielding. I want to let you know that if you file a motion for shielding, first of all, in your handouts, there is a link for the court-provided form to apply for shielding for this reason. So you don't need to come up with your own original form to do this. That is provided for in your handouts. And but you should know that when you file for this, the state's attorney's office has the right to object. So if you tell somebody, oh, this is such a simple form, I'd be happy to fill it out for you, it's not out of the realm of possibility that you may have to appear for court and represent that person at a shielding hearing. It's important to know that because you need to be putting in writing when you are representing somebody how much you're willing to do along in the process. And we're going to get more into that in a second or in a few minutes. Now, so for what it's worth, there are an extensive list of parties that still have access to shielded records, okay? And so why shield? What's the point? And so the statute actually says what the primary benefit of shielding is, that Maryland Case Search is going to delete the existence of that record on Case Search. So, you know, when somebody applies for jobs nowadays, some businesses are looking on Maryland Judiciary Case Search, a free website to do criminal background checks because it's so simple. Getting something shielded, if that's how the employer is going to do a quick criminal background check of that person, that's going to be very helpful to your client because the employer is not necessarily going to be able to see automatically if they just go to Case Search. They're not going to be able to see those convictions. So that would be the primary benefit, in my opinion. There's another kind of shielding, civil cases, but only two kinds of civil cases that are available for shielding, and those are protective orders and peace orders. These are the statutes that are provided for the exact procedure that you need to know if you want to put in for shielding of a protective order or a peace order. These are Maryland's two kinds of restraining orders. Their primary difference is who you are getting a restraining order against. Somebody with some sort of a familial relationship is typically a protective order, and I like to say peace orders are somebody as close as a neighbor or more distant to you. It's important to know now, if you remember, if the detail I want you to remember from this lecture, before you delve into the statute to really go through all the criteria, is that you can only shield protective or peace orders if the person consented to them, or if the petition was either dismissed or denied. And this is very important because if you had a client who says, I want to put in for shielding of my protective order or my peace order, and they contested it and lost, they are not eligible under the statute for shielding. So be very clear with your client about that. And for practitioners, this is a good practitioner's note. With regards to if you lost and you were a protective order or peace order was granted at a contested hearing in the district court, and your client files an appeal, that appeal is de novo, meaning you'll get a brand new hearing in the circuit court. And if that client consents at the circuit court stage, or it's denied or dismissed at that stage, that reopens the ability to shield. So that's a good practitioner's note for all. There will be a court appearance for this kind of shielding motion. That's extremely important to know. Very simple form. I provided for it in the handouts. All you have to do is find the link and you can fill it out. It's so easy, and you think, I've done it and I can just move on. I've helped this client out. There absolutely, the statute says there will be a court appearance for this. It's to give notice to the person that filed originally for the protective or peace order. They don't necessarily, that person may not show up, but you will. And so be mindful of that when filing on behalf of your client of exactly what you're signing up for when you assist somebody with that type of shielding. Sometimes your client might be asking you about out-of-state or federal cases. These expungement laws that I'm going to be talking to you apply only to Maryland crimes, Maryland state crimes. And so if your client says to you, I have a case in Massachusetts or Texas, you can't help them. If it's a federal case, you can't help them, at least not with this, and especially if you're not barred in the jurisdictions where they're asking you questions about. But this only applies to Maryland cases. So if you want to advertise and say, I want to help somebody out with expungements, and you're a Maryland attorney, be clear. I want to help you out to expunge your Maryland cases that are eligible. It's still good to ask your client about their out-of-state cases for the screening process as well as federal cases. We'll talk about that later, about pending cases. and how they can affect, or subsequent convictions, and how it can affect somebody's expungement of Maryland cases. So ask them about their full criminal record when you're meeting with them, but you can't help them to expunge it unless you're barred in those jurisdictions and know how to advise about that. All right, so this slide is a nice little homage to a professor many of us, I'm sure, had in University of Baltimore Law School in our first year. If you took civil procedure at University of Baltimore, he had this rule. He said it a lot less guarded than I've printed it here, but it's very clear, and it stuck with me forever. When you're handling these expungement, when you're handling a client's expungement, just go directly to the statute. That is a how-to guide of how to help somebody to expunge their cases. All of the answers are in the statutes. I think for reasons that make a lot of sense, this is not a very appealed issue. So you don't have to really be looking at the Court of Appeals or Court of Special Appeals for the answers. I'm really not aware of any opinions that have come out of there. Please let me know if you are, and I'd be happy to share it afterwards with everyone. But the statutes are very well written and they're very clear. So I provided all of these statutes here. The adult crimes are the ones we're going to spend the rest of our time talking about. There they are: Criminal Procedure 10101 through 10110. I've also shared with you, and it's in the attachments in the handouts, how to expunge a juvenile case and how to expunge your MVA records. This lecture is not going to discuss that, but those statutes are also the same how-to manual, and they're in your handouts. Review those, and you'll be able to answer your clients' questions about that. Okay, so finally, here we are, a bunch of slides in. I'm finally getting into, so what is an expungement? All right, and this is an important, it's actually much more important than you would think, because a lot of people think that the answer to that question is right there in number one, that if I get something expunged, they're going to obliterate my record, and that's great, and no one will ever know about it. When I was a baby attorney, I'm pretty sure I would tell my clients, you want to get this expunged, they're going to take that file and put it through the shredder. I'm sure I got that information by talking to somebody else, and it seemed to make sense. But not enough people pay attention to number two, and that's really what's happening, which is they're taking these files and they're putting in a separate secure area for which basically no one has the right to look at them. And that actually, more often than not, is exactly what's happening. And this is the image that pops into my head, which is like a scene out of the end of Indiana Jones. This is probably where all these files are, more often than not. I want you all to be aware of that. You don't want to tell your clients they're going to definitely take this file and put it through the shredder. Even though sometimes they do, but more often than not, they are actually doing number two. All right, so if they're not destroying the file, what is an expungement then? All right, so for what it's worth, the statute, and I've provided right here, tells you, well, here's what we're not expunging, okay? And they've created this list. I'm going to talk about two that kind of make the most sense. Number two, if your case went far enough that the court published an opinion, they're not going to expunge the court's opinion, even if they expunge the case. And we'll get a little bit more about why minor traffic violations are not going to be expunged, but that's because they're not eligible for expungement. I'll explain a little bit later what a minor traffic violation is. But this is what's not going to be expunged, even if it's linked to that case. So be aware of that. All right. In effect, again, still continuing on. So here's what an expungement means. So the statute says, and I've cited exactly where in the statute it says this, that the custodian of police records and court records shall expunge their records. All right. Now, what does expunge mean? It means obliterate, or it means send it off to storage at that separate secure location. The court is going to be doing this expungement. The law enforcement unit that was involved in the case is going to be doing the expungement. Booking facilities, I know I went out of order because I want to come back and talk about the Criminal Justice Information System Central Repository. That's a mouthful. Criminal practitioners will know that as CJIS. In the statute, it says they'll shorten that and just call it the Central Repository. These are the places that are expunging records. So if somebody else has a record, the statute isn't telling them you better expunge it. These are the people that are, these are the entities that are going to be expunging records. All right, so now it's worth knowing, and the statute says it, that it may seem like, all right, well, that didn't feel like what I hoped I would get out of this, all right, but actually An expungement is quite serious. It's actually a crime if the statute's not followed, meaning if disclosures of records are made in violation of the statute. It's a misdemeanor, punishable up to a year in jail. And government employees, government officials or employees can actually be removed or discharged from service if they don't follow the law properly. So that's got a lot of teeth, a lot of meaning, which is what we need our clients to know. Here's my longest slide. This is a copy and paste out of the statute. But at the end of the day, your clients are going to say, and this is the final answer to that question, what does an expungement mean? A lot of your clients will say, once I get an expungement, what questions do I have to answer and what questions do I not have to answer? When I apply for a job, do I have to answer this question? Do I not have to answer? Can I say no to certain questions? This statute answers that question. Number one, if you are applying for a job or admission to a school or somewhere, at the application process, or the interview, disclosure of your expunged information may not be required by an employer or an educational institution you're applying to, or if you're applying for a permit. That's one. Number two says that a person, meaning your client, need not refer or give information concerning an expunged charge when answering a question concerning a charge that did not result in a conviction or a conviction that the governor pardoned. This is more important than you realize, okay? Because now we have a statute that says in the last 2 years that you can expunge all these convictions. But actually, the statute only says that your clients need not refer to anything that did not result in a conviction or something that the governor pardoned. So we're talking about your null process and stats, things of that nature. In my opinion, I would say probation before judgments would qualify as something that did not result in a conviction. However, very experienced criminal defense attorneys will still advise their client that technically what happened there was that the client was found guilty, and then that conviction was struck, resulting in a probation before judgment. So in those situations, what I advise my client to do is read or take in the question you're being asked as literally as possible, so that you're always giving an honest answer. Now, refusal by a person to disclose information may not be the reason for that person to be discharged or refusing that person to be hired or denying them an application. I'm not sure, but I believe that this relates to the legislation that came out recently talking about ban the box, when people would apply for jobs and the employer used to be able to ask about criminal record, but now they have to get you through the interview process before they can look into that information. I believe that's what this relates to. All right, let me see. I think I have a question. So the question I was asked relates to a few slides ago, where I said I wasn't going to discuss juvenile stuff, but still a good question, which was, how can someone get access to their juvenile records to determine how to fill out the question on how the charge was disposed of, and can it be done in any fashion other than going to the juvenile clerk's office? I honestly do not know the answer to that question. I think it's the kind of thing where you start out and you just have to make a series of phone calls. I've never specifically done that for a particular client. So for me to know the answer to that would involve me going through that process and learn by doing. So unfortunately, I don't know the answer to that question. Okay. All right. So now that you know what an expungement kind of generally is, I want everyone here to decide before they decide. I want everyone here to make this decision before they decide to help somebody with an expungement. What kind of lawyer do you plan to be going forward? And I hope everyone that watches this lecture at least considers being the first bullet point, which is, you get a question, this isn't your field of practice, or it's just not worth your time. Maybe it's just, you have other types of cases you handle, and this is not the type of thing that you want to focus on. But I want everyone here to walk away from this lecture thinking, wow, there is a lot that can be expunged from people's records, and I do not want to be the end of somebody's path of trying to get to an expungement. And so at the bare minimum, I want everyone that watches this lecture to be the type of lawyer that says, I actually have some information on this. A lot is eligible for expungement now that didn't used to be. Those are changes that happened literally in the last 1 or 2 or 3 years. And I want to make sure that you're in touch with somebody that is going to be thinking about that. Everyone here should be that person, minimum. Now, if you want to take the next step and you want to be somebody that assists a client in the actual expungement, I advise everyone here, whether you're somebody that fills out the forms for the client or you're somebody that appears in court with them for a contested expungement hearing, I advise you to strongly consider the second question, which is, do you have a retainer agreement? And even if you're helping somebody out pro bono, for those 800 people that I assisted, I had them all fill out pro bono retainer agreements where I spelled out exactly what work I was doing for them and what I wasn't doing for them. And the reason for that is, remember, we are all lawyers. And so the system is always going to expect that we thought about this a lot more before we started assisting somebody. And so you may think, all right, I'll just quickly help somebody out and that'll be the end of it. Now, if that person, if there's a snag in the road at some point, that person may come back to you and say, can you assist me with this a little bit more? And you might have thought, oh, I was already done and I already assisted you with that. It's very important you put in writing exactly how far you're willing to assist this person with their expungement so that there's no confusion, because should they get a contested expungement hearing and you help fill out the form and you don't appear, you could get a call from a judge expecting you to appear for court. So spell that out in writing in advance. Okay, here are some things I want you all to think about before you file an expungement. First of all, whatever you expunge, any conviction you help a client to expunge are not expunged for federal purposes. And I put in parentheses immigration because I mean that to be included in that term, but there's lots of different federal entities that'll care about somebody's criminal record. It just so happens that immigration is the one that's the hot one for all criminal defense practitioners. So the feds don't care if we're expunging things. They're still keeping a record of all this type of stuff. So it's very important you tell that to your client, because if they ever want to apply for a federal job or if they're applying for some sort of admittance into the country for immigration purposes, they still have a duty to answer questions honestly, even if they expunge something. So it's very important to log that away. It's important to remember that non-citizens can still be deported even if they have a qualifying conviction, even if it was expunged. So don't tell your client, oh, we expunged that conviction, that won't be a problem anymore. That's the wrong advice. Also, very important, non-citizens have a duty. The duty's on them to prove that the disposition of their case went exactly great and wonderful for them. So if you expunge their case and the case is obliterated, for example, the file's obliterated, if they go with option 1 from the statute I showed earlier, that client may not be able to get access to those records, and they could get deported when they weren't deserving of that. So it's very important you have that in your mind. That client needs to be presenting a certified copy of the case to prove exactly what happened. I'm going to have a little bit more information about that. But what I would tell everyone here is, if you have a non-citizen client, you want to get them in touch with an immigration lawyer before they file, even before filing the expungement. And so that's the type of client you're going to say, I know that this is eligible for expungement. Let's wait. It's actually in your best interest to wait until we get advice from a lawyer who knows. Now, there are these, click ahead. Yep, there are these 3 steps. I got all of this information off of a form that's in the next slide. I actually, in preparing this lecture, and in preparing this slide, I contacted 3 different immigration lawyers at 3 different firms to let them know I was going to put this slide in here just to make sure that this information was still updated. And all of them signed off on this. So I'm not an immigration lawyer, but I wanted to make sure you walked away with some advice on this. So again, all of these bullet points are in the next slide in a handout that I'm going to show you, but this is the advice you're going to give your non-citizen client. You are going to advise them before putting in for an expungement to obtain from the court clerk's office and safeguard 5 certified copies of everything in the clerk's file on that case, including the charging documents and disposition. keep those in a safe location and give one of those copies at least to the attorney. If you, again, you don't need to remember that because these are screenshots of what's in the handouts. This is what I got from actually the Office of the Public Defender in Maryland has this on their website. I've had this checked with immigration lawyers. They say this advice stands up. There's a version provided for in the handouts, a link to it that's in English and one that's in Spanish. I hand out the Spanish speaking one to my clients because I don't speak Spanish. And I have a Spanish speaking lawyer in the office, but if he's not available to speak with the client, I get this in my client's hands so that they have this advice, telling them what to get before we put in for an expungement. So follow this advice. I'm getting a question. So the question I'm being asked relates to a slide I was asked earlier. With regards to the statute, it says, do I not have to answer, what questions do I not have to answer based on 10109? Does the prohibited acts apply to educational institutions outside of the state of Maryland when a citizen of Maryland is applying to it? So I don't know the answer to that question. I'm sure that the answer has something to do with full faith and credit. However, I would say that with regards to state crimes, I would advise the client to show you the question that's being asked and consult with you about that specifically. All you can do is advise about what the statute says. Again, you're not in a position to advise about out-of-state law unless you're barred in those states. So I can't give an answer about out-of-state. I can't give advice about, you're asking about out-of-state institutions and whether or not we have to disclose what happened in the state of Maryland. I'm getting a note here. I just want to respond to it. Okay, let me see the response. Okay, good. I was being told my video is freezing, but I'm told the audio is still working. Okay. Okay, now there is a statute that talks about how to get access to expunge records. 10108 is the procedure for how to do that. If you need a motion for that, I created one up from a client I had once that needed access to this. So it's actually possible. Remember, these are being stored somewhere. So it is possible to get access to expunge records. But remember, time is of the essence. If somebody's asking for you to get their expunge records back, they probably need it quickly. So handling it right in the first place is the way to go, as opposed to filing a motion that might get you those records back. Or you might find out they were obliterated. There's nothing you can do, and that person is really in a bad spot. Okay, what is eligible for expungement? I'm going to start talking about the statutes that tell you that. Here are the statutes that tell you how it works for juvenile delinquency matters, as well as minor traffic cases. Again, I'm going to only be talking about adult cases. These statutes are provided for in the handouts. All right, so this is the original statute that talked about expungements and what was eligible for expungement. It's still there. It's Criminal Procedure 10105. It's got what we would have thought about: acquittals, dismissals, PBJs, and obviously the statute doesn't say whether it's filing fees or not. I put that in there as a to assist you all, but I wanted you to know that the statute says exactly what kind of results are eligible for expungement. There is a short list of convictions that are mentioned there. We have another slide that deals with that. If your client has a civil infraction that also happens to be a criminal infraction, usually, but maybe that jurisdiction said we want to make this a civil infraction. My kind of go-to example I remember is, I forget which direction it goes, but I'm used to, in Worcester County, I believe, open container at some point, or maybe now, used to be a civil infraction. However, it is a crime that's provided for in the statute. Statute says it's a civil citation, but it's also technically been a crime elsewhere. Then you can actually, if the statute says you can get it as a conviction, you can expunge it. There are wait periods. The statute 10105 tells you exactly how long for each one of these types of results it is. It's if it's in 10105 as a result, the waiting period is anywhere from immediately while you're still in that courthouse to up to 4 years. Those are in the 10105 list. Okay. Now, out of 10105, these are all the convictions that are mentioned specifically in 10105. Now remember, this is just 10105. There's a whole other statute that talks about more convictions. These are so it's important to know, not all the convictions are in the new statute that I'm going to mention next. Some of them are mentioned in 10105. I want you to all remember as a mnemonic for your clients that anything that's a conviction is a $30 filing fee, whether it's in 10105 or in the statute I'm going to talk about next. If it's not a conviction, there's no filing fee. If it is a conviction, even if it's a crime that's no longer a crime, then there is a $30 filing fee. That's important to know because I used to help out a lot of people, especially when I was a public defender way back when. And it used to always be a $30 filing fee, even for the null process. And the clients would say, I just can't afford the $30 at this time. And now it's important to know the majority of cases that are eligible for expungement don't have a filing fee. So make sure you let them know that barrier no longer exists. Possession of marijuana is now on this list. When this statute first came, not when the statute first came out, what I mean to say is a couple of years ago, they amended the statute and added marijuana less than 10 grams on this list. And now it's possession of marijuana anyway, not possession with intent to distribute of marijuana, possession of marijuana. That is now eligible for expungement. And then what I call, it's in italics as a note to myself, called nuisance crimes. I don't remember where I got that term from. If I mistakenly have adopted that term, then it'll be my term. But this is the category of crimes on the right side of your page. They're all there. Public urination, panhandling, loitering. I have handled probably at least 50 of the riding on a transit without paying applicable fare. They're out there, help people to expunge these. The question that just came in, that will get more answered. It deals with a specific conviction that will get answered later in the lecture. If you don't feel like I answered it, please ask it again. Okay, and that dealt with an Alfred plea question for the person, so you know who I'm referring to. Okay, so 10110 is the big statute, and it's the reason we're basically having these lectures, because this is the massive change in the law. It was created by Justice Reinvestment Act. Every single conviction listed in there is a $30 filing fee. Anytime we're talking about a conviction, most of the conviction we're talking about are provided for in that statute. I'm not obviously going to provide a copy of it because it really is a huge statute. I am going to highlight what's contained within it. Okay, there are 5 specific felonies, only 5 felonies that are mentioned in that statute. So if your client says, great, I heard there's this huge list, I got all these felonies I want to get off my record, I've had these convictions forever, they've been the bane of my existence, you can very quickly screen that person by saying, well, what were the convictions? Because if it's not felony theft, possession with intent to distribute of any kind of drugs, or first, second, or third degree burglary, it is not eligible for expungement unless it got a probation before judgment or a null process. But as a guilty, unless it's one of these 5, not eligible for expungement ever. There is and now in terms of our non-regular criminal defense practitioners, felony theft, what I mean by that is our theft statute says, theft is divided up in terms of penalties based on the amount of money the property was worth. It's a felony if it's over a certain amount. It's a misdemeanor if it's under a certain amount. The original statute just said misdemeanor theft. Now felony theft is eligible. There are a long list of misdemeanors on this list. That's why this slide is not showing. I've put the 4 or 4 or 5 technically, that I think come up the most, or that people are really relieved are now eligible for expungement: misdemeanor theft, second degree assault, possession of any kind of drug, violations of protective and peace orders. I have provided in the slides or in the handouts a link from Maryland Volunteer Lawyers Service. It's a wonderful organization. I encourage everyone here to donate time to them in any field that they're looking for help. Right on their website, though, they went and translated the statute, and you can just hit Control F on your computer and search for convictions by name, and quickly figure out if your client's conviction is going to be the type of conviction that's eligible for expungement. So I've just given the ones that I think are the ones that people are really hoping for. Doesn't have everything. For example, fourth degree burglary has not made the list yet, and that's amazing considering first, second, and third degree burglary as felonies are eligible, but fourth degree burglary isn't. So you got to go through that list. Things that you hope would be there are not. Things that you're surprised that there are. Now, there are wait periods. So this is where the excitement ends when it comes to this statute, and the wait periods are 10 or 15 years if it's provided for in 10110, and it says it right there in that statute. That statute is a great how-to manual. The 15-year wait applies to battery, any crime labeled domestically related, and the felonies. All right, everything else in that statute has a 10-year wait. And remember, if it's a conviction that's in 10105, those have shorter wait periods, okay? So there's no wait for crimes that are no longer crimes, 3 years for the nuisance crime or 4 years for possession of marijuana. But if it's in 10110, we have this wait period. What is a domestically related crime? We don't have a crime of domestic violence specifically in Maryland. What that means is if you ever have a case that involves some sort of fact pattern that is clearly domestic violence, the state's attorney will say at the result, Your Honor, I'd like to have this file marked domestically related. That's what it means by it. So it could be assault and battery, or it could be a harassment. But obviously, those are charges that aren't always domestic. So some harassment charges are going to have the 10-year wait, and some harassment charges are going to have the 15-year wait. Also, it's important to know. Let me see. In case I don't have it at the later slide, it's also important. Yeah, there it is at the top of this slide. That wait period, this is the other thing that's very annoying about this statute. That wait period begins at the end of sentence. It doesn't begin from the date the person got a conviction. And so when you're doing the math with your client, if you're looking on case search, you're not just looking at when they pled guilty to figure out when they're eligible. You're looking to see how long was their sentence, how long were they on parole, how long were they on probation, how long were they supervised for those periods, and how long did they serve their sentence, and then count from the end of that time period. That's when they're eligible. So if somebody served 5 years flat on a second-degree assault, they're eligible 20 years after they originally pled because they'll be the 15 plus the 5. Beware the subsequent conviction. All right, this is huge. This applies only to the crimes listed in 10110. It used to apply to everything listed in 10105. They changed that. We don't have the new conviction effect anymore, which is great for all those things in 10105. But beware of this. If somebody gets a new conviction during that wait period, it's going to block their ability to get an expungement until that new thing becomes eligible for expungement. Remember, we're lawyers, so read that literally. They don't have to actually expunge that new thing. That new thing just has to be eligible. But if that new crime, for example, let's say your client gets a second-degree assault 20 years ago, and 10 years after that, they get a driving without a license conviction. That driving without a license is not on the list of crimes that are eligible for expungement, and it is blocking that second-degree assault. So that's why you want to ask your client about their whole criminal record. Remember earlier I said talk to them about their federal record, out-of-state things. State's attorney's office are screening for this. They are giving more scrutiny to the convictions that people are trying to expunge. And so they'll look if they think there's reason to believe your client is context out of state to see if they have those out of state things. So you want to ask in your interview and save your client the time of filing for an expungement that's not going to go through, because that's going to involve a court hearing where all they're going to hear is bad news. Second, beware. Beware the pending case. For all kinds of expungements, in the statute it says if you are pending, you're not eligible for expungement. I'll show you the forms later, and it'll even say, does your client have any pending cases? Don't apply. But sometimes they don't write that on the forms, and I'll point out where they didn't point it out, write it in the forms. The statute says your client's pending for any kind, whether it's 10105 or 10110, some sort of new case. They're not eligible no matter how old that case is. And it's pending a criminal proceeding. So what is a criminal proceeding? Well, very annoyingly, and I say that from a place of the person that's doing this volume of work, criminal proceeding is not a defined term. You would think it's just a new pending case. Oh, they got a new charge, it's pending. As soon as it's done, it'll be fine. But actually, I sort of made up this sentence. It's any non-civil court appearance excluding minor traffic. which is a real hodgepodge of definition there. But basically, what you're seeing, what I've been seeing is if my clients, they get this probation, and so if your client's on probation, they're not pending. They're serving a sentence. They're not pending. If they're on parole, they're not pending. But if a judge says, hey, I'm going to give you the benefit of drug court or an 8505, 8507, I'd like to see you periodically for statuses and bring you back into court just to visit with you and see how it's going, that's pending. And you'll know it because what you're looking out for is the case open or active, or obviously you're looking out for warrants. And this is a real shame because I'm a real advocate. I love drug court. I love 8505 and 8507s. They're some of my most positive experience with clients, watching them and getting to see them come back and get better. However, just the mere making of that case active so that the judge can see this person, visit with them for status conferences, even if it's a good news type of visit, is blocking their ability to expunge something eligible. I beg those clients to really beg their judge, I'm happy to see you. I'm happy to visit with you as frequently as you want. Can you just make this case not active in between so I can put in for an expungement? I've never had a client follow up with me about the success of that, but that's what's blocking them. So if you have a client that's in drug court or 8505, they also probably have a pending criminal proceeding. Let me just check. Someone asked a question. Somebody asked a question about expunging a juvenile matter. I will just be full disclosure here. I've never assisted a client to expunge a juvenile matter. I really do find, I should correct that. I've never helped a client expunge a case that resolved itself within the juvenile. There is a way to expunge cases that are transferred to juvenile where you can expunge the adult case. That's provided for in 10105. My advice to anybody asking about expunging the juvenile matter that resolved in juvenile court is to follow the statute. I really have found these statutes to be great how-to manuals. Okay. All right, and it would be really helpful for me, for the person that's typing to me the questions, if you can just delete out any that you've noticed I've answered so that I can know there's questions I haven't gotten to. Thank you. All right. Okay, so anything. All right, what isn't eligible for expungement? So, as I said, anything while pending a criminal proceeding. PBJs, when DUI is an element, that's my way of writing it. Actually, what the statute says is probation before judgment for a DUI or, a DUI homicide. These things are not eligible for expungement. Right away, you're going to have clients that want to expunge the PBJ they got for a DUI. They're never eligible for expungement. Never, ever. The court literally does not have the discretion. That is a...
Hey, Eric, we've lost your audio.
You lost me?
Nope, you're back. Go ahead.
Okay. I just want to say that to me, it is a shame that we have selected out DUIs as the one crime that cannot be expunged when other crimes are eligible. I think if something's a PBJ, the point is that we didn't want it to be a conviction. Convictions, I used to always say, are like diamonds. They're forever. And obviously, that's changed a little bit since we have 10110, but I think that's a shame. I wish it would change. I hope somebody watching this video agrees with me and wants to discuss that further with the powers that be. PBJs, when you get a new conviction within 3 years. So for every other kind of PBJ that your client ever gets, if they get a new conviction within 3 years of that PBJ, the statute also says they're barred. It's important to know because if you just start filling out all your clients' PBJs for expungements and without regard for a subsequent conviction, you didn't realize they're barred. And you want to save them the time of an unnecessary expungement hearing. And what they have to do is they really need to expunge that new conviction. And if they can, then they can go back later and expunge the PBJ. Civil cases are not eligible for expungement. That's different than what I meant about civil citations. I'm talking about your divorce case. These are not eligible for expungement or your personal injury lawsuits. Most convictions are still not eligible for expungement. So when you look at 10110, it's a huge list. But what I always tell people is before I do all this looking into it, I want to make sure people's expectations are right where they need to be. That there's a lot that's eligible, but not as much as we hoped it would be. So be optimistic, but be realistic about that, and that'll help keep people positive through the process. So that if you have to come back and say, I'm sorry, you might give the same information I give. I keep all my clients' email addresses. I send out an email twice a year to all my clients to tell them when the law is updated. I recommend you do the same service for your clients. Okay, this is the next thing that most people find extremely annoying. It's called the unit rule. This is the statute, exactly where it's provided for. There are two versions of it, which is to say there are two kinds of ways it can be implemented. The second one, obviously, so important. They wrote it twice in 10.110. And so here they are. If two or more charges other than a minor traffic violation arrive from the same incident, they are considered to be a unit. I'll explain that with an example in a second. And if a person is not entitled to expungement of one charge or conviction in a unit, they're not entitled to expunge any charge or conviction in the unit. Again, I'll give you a visual example of both now. So as to the first one, if your client was charged with driving on suspended, driving without a license, and pled guilty to driving without a license and got a null pros for the driving on suspended license, in Maryland, the way we deal with that is you actually, we have this old-fashioned system, one case number per traffic ticket. And so if somebody got charged with 10 tickets or 10 traffic violations, they were getting 10 case numbers. Routinely, when I do expungement reviews, my clients that seemingly at first glance have the worst records are the ones with bad traffic records. I'll help somebody out that's got, 10 convictions and they're on one page of Maryland Judiciary Case Search, and then I'll help somebody out that's been pulled over 10 times by the police for traffic violations and they've got 5 pages on Maryland Judiciary Case Search, and it gives a terrible impression. But technically, even though they got different case numbers, they are considered part of one unit. And so if one of the case numbers got a result that's not eligible, then none of those case numbers are eligible for expungement, except for when it's a minor traffic ticket. So for example, if your client paid failing to stop at a stop sign and then null pros driving on suspended, the driving on suspended is eligible for expungement, but that payable citation isn't going anywhere. But your client's going to be fine with that because you just tell them, hey, what I tell my clients is, this is minor traffic. And that makes them feel a lot better. And really, realistically, it probably is, it should. The second example is your client that is charged with multiple crimes. This is the usual, where one case number, lots of charges. And, my example I came up with is your client gets charged with attempted murder, use of a handgun, and commission of a violent crime, first degree assault, second degree assault, and you pled him out to second degree assault, and that was maybe under those circumstances, it was an incredible deal, and they null pros all the other charges. In Maryland, that's a unit. That case number is one unit. So even though all those other charges got null process, one of the charges is a guilty. So what I do is when I open up a case on case search, I'm just looking for the word guilty. I don't care about all the null process. I'm looking for the word guilty. Once I see that, I know the unit rule is going to be applied. And so when I taught this lecture a few days ago, somebody asked me about this because I said, and then their second degree assault's never eligible. So I want to make sure I correct that. Now, this case is not eligible for expungement except for the specifics of the example I gave you here. Second degree assault's obviously eligible, but it's got that 15-year wait. So if on the other hand, your client had pled to first degree assault and all the other charges were dismissed, it would have been never eligible for expungement, no aspect of it. And then what happens is, what we know is going on. People are going through life and somebody goes on the case search, they see this attempted murder and they think the worst of them, even though you pled it out to a much lower count, they're going to be judged for even the most serious sounding dismissed charges. And that's how the law is applied at this time. Okay, so there is a thing called a good cause exception. So there is a way to put in for, I'm getting asked this question real quick about fourth-degree burglary because I brought it up. I am aware that the legislature is trying to correct whether fourth-degree burglary would be added to the list. Keep checking back with Maryland the law. As of right now, I don't believe it's made the list at all. I'm pretty sure the legislature took it up this year, but your obligation is just to go to the most updated version of the statute. Okay, good cause exception. So, they have these wait periods. However, the court's allowed to consider an earlier time for good cause. Now, if they want to let you get an expungement sooner. Good cause is undefined, okay? I don't have an explanation of what is good cause, okay? I wish I did, but this is the one where Every judge is going to apply their own life circumstances and what they bring into that case and to decide what is good cause. And so that's just you being a litigator, arguing your case and preparing it as best as possible to say why your client is deserving under the circumstances. Judges are very hesitant to grant for this reason. So be upfront with your clients. Don't just say, oh, that's fine, we can go in for it. I mean, there's a reason why we're not all filing for good cause exceptions. It's because we know that the judges are not in mass dying to expunge cases earlier than they're supposed to be. And that's not because they have a point of view. It's just because what's the point of this law of waiting to have it on your record if we just want to let everybody have it expunged sooner? It really is meant to be for good cause. And so there's no official court form in your materials for filing a motion. This is the one where you have to draft up your original motion and say, you know, my client's I'd like to put in for expungement for good cause reasons, and I'm detailing those reasons. There will be a court hearing for this, so be prepared for that. The state's attorney will object. And also, if you apply for an expungement using the court forms and then the state's attorney's office objects, amend your application and add a good cause filing, and that would be a good way to prepare. It's certainly not a guarantee, but I think it's just a smart use of the preparation of your time. All right, so finally, here we are. We're getting into expungement procedure. If your client's eligible, this is actually the easy part, you know? So that was a lot of information, but once you said, yeah, you're eligible, the good news is it actually goes pretty straightforward from here on out. There are two versions of the form that I provided for in the handouts for petitioning for expungement. I'm going to show you them in a second, both available on the court website. They're enabled with text boxes. So you can type directly into them from your office and help the client fill them out. You don't have to go to the court clerk's office to get these forms. You can get them on your computer and fill them out right then and there. One kind, there's a $30 filing fee. The other one, no filing fee. I'm going to point out which ones they are. And sometimes there's a second form in your handouts where you have to do a general waiver and release. I'll mention when that is. Here's the first form. It says it right at the top. If you can see my mouse, I'm circling where it says guilty dispositions. They have a $30 filing fee. And so you got to fill out this basic information about the history of the case. Try to get it accurate. I've had clerk's offices that reject these if you put the wrong law enforcement agency. You think it's the state police, but it's actually some local police department. Get that right, or a careful clerk could reject it for those reasons. So, that is the top of the form. I've taken a screenshot of it. The nice thing, this is further down that same document. If you want to forget everything I just told you and you want to start your research from looking at the form, you can actually do that. The form says, all right, here's all the guilties. And it says what statutes to look at to find which convictions might be eligible. And then you check the box that applies when you realize that there it is. So if you lost the handouts from this lecture, just get these forms and they'll tell you how to start your research. If it's anything other than a conviction, this is the other type of form. This form has no filing fee. Same deal, fill out the top. I didn't mention it before, that section at the top right-hand corner about the tracking number. Traffic citations do not have a tracking number. Criminal cases do. So if you're racking your brain trying to find the tracking number for your traffic citation, there isn't one. Don't worry, the clerk's office is not going to reject it. You don't have to fill anything out in that space. They expect it to be blank. This is further down the same page. Same thing, the check boxes. You check which reason applies to your client. Again, you'll see in here, there's a lot of conversation about, whether it, I'm sort of blocking it with my screen, but they'll be mentioned in here, does your client have a pending case? But not all of them say that. For example, the acquittal doesn't say, do you have a pending case? But the statute says if it's pending, it's blocking you. It also tells you when you needed that general waiver that I talked about before. If it doesn't say it, you don't need it. It's applied to these cases that are 3 years or less old. Here is that general waiver. Just read it very carefully. It's basically saying your client can't sue the police department to charge them with the crime. If they have an active lawsuit, don't have them put in for the expungement on that case. Just tell them to wait to put in for the expungement until after they've handled the lawsuit. Okay, how are we doing on time? We're doing great. So the procedure is these forms need to be submitted to the court, okay? Court will accept them by mail, they'll accept them in person, but if you, the lawyer, wants to file them and you're in an MDEC e-filing county, then you have to file it through MDEC. if you, the lawyer, walk it up to the court clerk's office, they will smile, ask you how your day is, and tell you to go file it on MDEC, okay? If your client walks it up, they won't do that, okay? But if your name is on it, if you signed it, they'll hand it back to the client and tell the lawyer to go file it, okay? It needs to be submitted to the correct courthouse. What do I mean by that? Well, got to go to the correct county. This is different. For example, we all tell our clients, oh, the court issued you a fine in the district court. You can pay that anywhere in the state of Maryland. That does not apply for expungements. They have to be filed in the correct county. And not only that, but they have to be filed in the correct courthouse in that county, meaning you want to file it in whatever courthouse the case finished up. So if your client paraded jury trial was indicted, you're filing in only the circuit court. You don't have to file also in the district court. But if you file in the district court, it'll get rejected. Or you might get a court notice to appear to explain to you it was rejected. So just file where the case was resolved. Oh, and also it's worth noting, if you file in the wrong county, they're not going to, as a service to you, file in the correct county for you. They're not going to send it over. They're going to reject it, okay? And I felt like there was something else I wanted to say about that. I don't know if I remember it, I will mention it. Okay, at the bottom of both of those, this is a screenshot from the bottom of both of the two forms I showed you. These are the signature lines. I like to highlight for private practitioners and really all lawyers, there's no requirement that the lawyer sign this. I thought this up when I reviewed, when we all do our tax filings around in April. It always says on those forms that if somebody helped you prepare those forms, that tax preparer has to sign it. It doesn't say it on these forms, and I'm glad it doesn't, because I think it's a barrier. If I had to sign every form I helped out with, I might be not inclined to help 800 people out to expunge 7,000 cases. And so, and then I'd have to find some other way to do good with my time. And so, but if you do fill it out, you're going to get the notices. And you may want the notices. You may want, even if you know what's going to go through, you may want the notices so that you can help keep your client informed. But if you don't fill it out, only your client is going to get the notices. All right, so you should tell your client how long this is going to take. Okay, and if not, they may just ask you, and here's the answer. So first, there's the law, and then there's in practice, how long does it actually take? So the law says, for the first 30 days after you file it, the state's attorney in that county has the right to object. Court will give them that 30 days, and then after that, the court will sign an order, and the next 60 days, those agencies that I mentioned earlier got to expunge those records. In practice, here's what I tell all my clients, and I got this information by just listening to court clerks tell the same information to my clients. Depending on the county, you're going to hear 3 or 4 months. Some of the largest jurisdictions might say 6 months. I tell people it's going to take about 4 months. During COVID, some courts are they're not treating these as an emergency, okay? And so that's going to slow down, and just prepare your clients for this. There was a question here about, can you file with only the attorney's signature? I think the answer to that question is no. I'm not sure, but I do recall that I had one case before where a client of mine passed away, and there was some sort of minutia within the statute where there was a way to put in for an expungement if the case had not been resolved yet. So basically, you need your client to be signing these. That's why I tell people to meet with me in person. Otherwise, really, if somebody wanted to just do this over the phone, it would be always easy. You can email them the forms, tell them to scan it back to you. But no, they really it needs to be your client's signature. That was a good question. All right, with regards to that 30-day objection period, I'd say 23 out of the 24 counties are abiding by that when we're not in the middle of a pandemic. I have noticed in Baltimore City specifically that they've been giving them more than 30 days. That's just some practitioner advice, something to point out to your clients so that they know that you know what you're doing. Some courts just say, and again, this is something I've noticed with Baltimore City, where they want to make sure that the state attorney's office is screening these. I've heard this anecdotally from other counties. That's very frustrating, especially when you've looked at it, you were thorough about it, you realize it's eligible, and when you get to court, the state attorney says, yeah, well, I don't know why this got said, and I'm sorry you had to be here. But that can happen. Tell your client, even if it's eligible for expungement and you're certain of it, it's possible they could have a hearing. You want to tell them that in advance so that they don't come back to you later and you have to look like you're backpedaling when this is something you knew up front. let them know they're going to receive this stuff in the mail. Okay, they're going to get a lot of mail. They may get mail from all of those different agencies I was talking to you about, and they should know to expect it. They're going to get an expungement for every case. So let's say you help somebody expunge 5 cases. They're not going to put them conveniently all in one form. They're going to get a notice about every single case. And if you have an inpatient client, which I would be if I wanted something expunged off my record, teach them about Maryland Judiciary Case Search. What I like to do as a nice, easy hack to life is tell my clients, if you can't see it on Case Search, it probably was expunged, and you'll get some good news coming in the mail. That will stave it off, because I have lots of clients. I'll fill out the forms. I'll tell them, hey, 4 months. They'll call me 2 weeks later. And I've got a lot of other things I want to be doing. So I take the time to explain to that client how to work Maryland Judiciary Case Search to look it up themselves. And that will save everyone a lot of time. Okay. If the state's attorney objects, the case will be set in for an expungement hearing. How's that work? Argue the statute. That's your code. That's what you're going to be doing, okay? Who has the burden? I would tell you all to be prepared that you have the burden. It's in my opinion, I think the state's attorney should have the burden because they're the objecting party, but some courts will certainly make that your burden. So be prepared. Come with everything that you feel like you need, because this is, this is not like some huge federal case. You don't want to be going back 2 and 3 times. You want to be prepared the first time and knock it out of the park that first time. And again, if you filed using the regular forms and it's objected to, consider amending and adding to your application good cause reasons so you can argue that in case there's something you missed and you still want to help that client out. And here's the good news. If you lose an expungement hearing, you can refile again when the client's eligible. So if you realized, oh my God, we filed too early, you're not barred from filing again. That's as opposed to with shielding of convictions. You're only allowed to apply for shielding of convictions once ever. And so it's very important that you know that. But with expungements, you can file for the same case over and over and over again. Obviously, at the bottom of that signature line, it said that you were authorizing that you only filed this if you really thought you were eligible. So that person shouldn't just turn around and file one the day after it's rejected. But the good news is when they become eligible, you can help them to expunge it again, or you can try again. All right, we're getting close to the end. So why recommend an expungement? I'm sure that seems obvious, but to those that's not, I really want you to think about this. This has been the bane of people's existence. This is an awesome opportunity to help people out. I can't tell you how many people, first of all, they're the best thank yous you're ever going to get, whether you're charging for it or you're doing it pro bono. This is the best thank you you're going to get. I remember I helped somebody out at a homeless shelter who had a 30-year-old stet for a rape, and that was eligible a long, long time ago. And this person was befuddled as to why he couldn't expunge this, or why his life had gone so downhill. And in my opinion, and maybe there are many reasons, but seeing that stet on his record, there's no way that helped him get a job for the last 30 years. We need to be on the lookout of helping everyone, whether it's our clients or just passing along the information. Get the word out. If things are eligible, people should be looking into this. Now, there's another buzzword we all know. It's called collateral consequences. And if my little sales pitch wasn't good enough, think about these collateral consequences. Criminal record can affect a non-citizen's ability to enter and remain in the United States. So that's a huge issue with criminal cases. Remember to tell your client to get a copy of the record before they file 5 times. Follow the links that I gave you for exact instructions. Employment. If employers are not required to hire somebody with a criminal record, so if you can expunge a conviction, that is a game changer. And if you're the type of person that feels like we all need to lift ourselves up and just get a job and not live in a welfare state, well, a simple expungement for somebody that's eligible is probably going to get us there. So, or it's going to at least start that path. So if you're somebody that feels like we need to be tougher on people, we can also show them how to expunge things, okay? Family law cases, your criminal record can affect your divorce and your ability to have custody of your children. When you're putting together these types of cases and you decide, maybe I'll hold off filing, I could put in for an expungement my client and then we could file. That could dramatically affect the trajectory of that case. Federal housing can be affected by a conviction. They can take away your federal housing, whether it's your client or someone that lives there has a criminal record. It's not just drug crimes. And student loans can be taken away. You can be disqualified from loans just for being convicted of possession of drugs. So be mindful of that. And if that's not good enough reason for all of our lawyers that are filing lawsuits, maybe before you file your lawsuit, you want to clean up your client's record so that they're more credible. And here are the 3 rules of evidence that make your client less credible when they testify. So if you've got a 3-year statute of limitations, maybe spend the first 4 months of handling that case, putting in for an expungement of your client's record, and doing a better job to help them with their civil lawsuit, while at the same time just helping them out in life. All right, this is basically my last slide, which is, so if you have any questions, start typing them now, but I want to make sure everyone leaves here with the same information you gave earlier. What kind of lawyer are you planning to be going forward? Be at least number 1. Give out that at least the non-specific advice with plans to refer out to others. Make sure you are not in the end of the maze to that person. Or are you going to be the type of person that fills out forms for that client or appears in court if necessary? And if you are going to be that type of person, have a retainer. You know, if you don't want to be that type of person, look, I'd love to handle all these cases. I'm happy to have you refer them to me and I'll take care of it, and that'll be wonderful. But if not, get a retainer together, have one in advance so you're ready to go and you're streamlined to assist that person right away and keep that positive process moving forward. If you're interested in handling expungements, but you don't have a client handy to do that with, there are plenty of places that can help you with that. Maryland Volunteer Legal Service, Pro Bono Resource Center, your local bar association, we usually host these programs. Reach out to them. They're often handling programs for this express purpose. And also get a mentor. I'm happy to volunteer to be the mentor for everyone that is watching this video. If you have questions going forward, I've given you all my information. I'm about to give it to you again. Reach out to me if you have questions after this lecture. And there it is, my information. So that is the whole lecture. I did it in the amount of time that they asked me to do, which is a pure victory for me. And I'm waiting to see if there's any extra questions. No questions at this time. All right, well, I will sit here idly for about 1 or 2 more minutes and see if anybody has any extra questions.
Well, thank you, Eric. I really appreciate that. We really are grateful that you took the time to share your experience and so much practical information on expungements and dealing with clients and managing expectations. I appreciate you answering questions as the presentation went along. And I want to thank everybody who's joined us today for this presentation by Erik Addis of Zirkin and Schmerling Law. We hope everybody finds these presentations to be timely and very useful. We're doing this obviously to help all practice areas that are impacted by the pandemic. You're probably going to have clients that are reaching out for help with expungements as everybody's employment situation, could be fluid. So if you have topics that you think could be covered that we haven't covered up to this point, please reach out and we'll try and find presenters. We obviously make sure that we provide all kinds of practical, useful, experienced presenters on topic. And with that,
I do have one question that's coming through. If you want, Ms. Terry, I can answer. It's very straightforward. The question is, what would you charge for a no bono expungement? I'm assuming that means low bono, but let me just check to make sure the next question isn't amending it. Okay, it's going to come through. So what would I charge? I mean, so I provided for it in my links. I'm at a stage of doing this where I actually, for me, it's very streamlined. I'm doing it a lot quicker than a lot of people. I'm not doing a lot of original research. So right on my website, it says we do this for, I will look at somebody's complete record for $350. I've seen, a lot of lawyers will be around 500 per case. I don't like that. But that I would say that if somebody said to me, I need you to attend an expungement hearing, I would think of like a normal value of my time. But if I'm just looking at somebody's criminal record on case search, and they have a young enough record that I don't think it's older than what would be on case search, which is cases that are in like the early 80s and before that, then I feel like I can give them the full service, fill out the forms, and help them to get it filed. And we charge a flat fee at the firm of $350 to do that for all of the cases. I don't charge per case. I know a lot of lawyers do. It's certainly a prerogative, but that's what I charge for it. So that's the answer to that question. A couple other questions are coming in, not too many. Let's see. Yeah, so as far as a question that's being asked about educational institutions, and it's being pointed out to that person, I'll answer it again. So the question again, is educational institutions outside the state of Maryland and employers, do we have to disclose which was expunged in Maryland? And my best guess and honest answer to that question is there's probably a little element of full faith and credit to that. However, this is a Maryland law. And if we're talking about an institution that is outside the state of Maryland, then you're talking about how is the law enforced in that state. And so I would say that if you have a person in that situation, you need to say to them, I actually want to refer you to a lawyer in that state to best answer that question. I'm not in a position to answer how things work outside the state of Maryland. I'm barred in the state of Maryland. I do criminal defense throughout the state, but I just can't answer out-of-state questions like that. That's my best answer to that. And I think that is it, Ms. Terry.
Okay. Well, thank you, Erik. Thank you, everybody, for joining us today. As I said, if there are topics you want to see covered in one of these webinars, we're happy to entertain. We'll try and organize it for you and get it out to the audience quickly. And thank you for joining us today. Erik, thank you again. Erik Addis with Zirkin and Schmerling Law. Everybody have a great day.
Thank you.